So let's talk about the Corporate Transparency Act, what it is, what you have to do to comply if you need to comply, and things like that. So we'll talk about the act itself, the primary goals of the act, how you report if you need to report, the penalties for not reporting, who needs to report, what needs to be reported, and the deadlines for reporting. Okay. So the Corporate Transparency Act is a bipartisan act that was passed in 2021 to unmask the shell and front companies. So essentially, the goal was to target the corporate structures that are hiding the owners and big decision makers. So they're really going after the dishonest people, not the honest people. But unfortunately, because there's so many bad actors, that they're actually trying to unmask them, to find them, but everyone has to now fall under, everyone has to follow this new rule. So this law requires them to reveal the beneficial owners of these companies in hopes of preventing criminals from misusing the U.S. financial system. So who enforces the Corporate Transparency Act? There is a small agency called the Financial Crimes Enforcement Network, and they're implementing this law, and it's called FinCEN for short. FinCEN is a part of the U.S. Treasury, and FinCEN is best known for regulating financial institutions and money service businesses. So again, let's go back to what FinCEN is trying to do. They're trying to combat criminal activities like money laundering, drug and human trafficking, tax fraud, and other criminal activities that companies are used to kind of hide, those shell companies where they're doing this criminal activity, but they can't figure out who the owners are, who the bad actors are behind the scenes. Okay. And in creating this law is actually meant to minimize the burden on legitimate small businesses. Because if they know who all the owners are of these businesses, then it's easier to stop the bad actors and not cost the government so much more money. So it really just is to combat crime. But now we all have to follow this rule. So who needs to report? Short answer, they're called the reporting company. So what is a reporting company? A reporting company, a domestic reporting company, is any legal business entity that is formed by filing a document in any state's Secretary of State's office or tribal equivalent. So if you file the form to create your business, whether it's an LLC, a corporation, an LLP, you are a reporting company by definition. Now there's a domestic or there's a foreign reporting company. Foreign reporting companies are any legal business entity that is formed abroad but is registered to do business in any Secretary of State's office or tribal equivalent. So basically, a foreign company that is registered to do business anywhere in the U.S. is also a reporting company. And the types of reporting companies, like I mentioned, are corporations, LLCs, some partnerships like the LLP, and some statutory trusts. And I'm going to talk about trust in a limited capacity, just to talk about how they fall under this law. What's not included as a reporting company is a sole proprietorship or general partnerships, because neither one of those you don't have to file anything to create a sole proprietorship or general partnership. You can just start doing business and you don't have to file anything. So those are not considered reporting companies. And now let's talk about the exemptions. the companies that would be considered reporting companies under the basic definition, but are exempt for other reasons. So there are 23 types of exemption, 23 types of companies that are exempt under this law. And I've given you the full list here, so you can take your time later and take a look at it. But mainly it covers companies that are already heavily regulated by the government, and tax exempt entities, large operating companies, and inactive entities. So I'm going to cover those last three that are highlighted there, but I just wanted to show you this list. A lot of these other companies are either banks or financial institutions or companies that are regulated by the SEC. So they're already reporting to the government in other ways, so they're not included under this law. Let's talk about the tax exempt entity exemption. So any entity that is an organization under the 501c of the IRS code and is exempt from tax under the 501a in the IRS code. So that basically means, for example, 501c3 nonprofits that are exempt from paying taxes. They do not have to report under this law. A political organization that's defined under Section 523E1 of the IRS code and that are exempt from paying taxes, those political organizations also fall under this exemption. And also there's two types of trusts that can fall under this exemption. One is a charitable trust that is not exempt from paying taxes. I know it's a little different from the other ones, but there you have it. And the second one is a non-exempt split interest trust. So if you have trusts that fall under those two, you will fall under this exemption and not have to report. Another type of company that doesn't have to report is a large operating company. Okay, and that has specific guidelines to fall under this exemption. Any business that has more than 20 full-time employees, and if there's a company that has subsidiaries, they can't combine the number of employees across subsidiaries. Each subsidiary has to have more than 20 employees to fall under this exemption. If the company has a physical presence in the U.S., this does include home-based businesses. It's not specifically a separate business location from your home. It's if you have a business office anywhere in the U.S. So home-based businesses, your business office is at home. So you have a physical presence here. And if the business has more than $5 million in gross receipts or sales on the previous tax return, if they make that much money, have more than 20 employees, and have a physical presence in the U.S., they are exempt from this law, from reporting under this law. And that 5 million must be aggregate sales by the U.S. affiliates and subsidiaries under a company. And it must exclude the gross receipts and sales that are made outside the U.S. So any company that can fall under this exemption cannot include sales that are made outside the U.S. And finally, the inactive entity exemption. This is a very hard exemption to qualify under because you have to meet every single qualification that's listed here. So the company has to have been formed before January 1st, 2020. It can't engage in active business. It can't be owned by any foreign person in any way. There has to have been no change in ownership in the last 12 months. and there has to have been no transfer of more than $1,000 within the last 12 months. And the company cannot have any assets or ownership interests in any other entity in the US or abroad. So it really has to be inactive. And basically, it was formed before 2020 and is not owned by a foreign person and is not doing anything in the last 12 months. So if you don't fall under this exemption, you are a reporting company that has to report. Okay. Now I'm going to take a quick moment on trusts because this does apply to this law, but in a very specific way. Trusts are usually formed with a trust agreement, not a filing in a Secretary of State's office. So trusts are basically the agreements that are formed. You're not filing anything with the Secretary of State to create a trust. Therefore, trusts themselves cannot be reporting companies. However, a trust may own a legal entity that is a reporting company. For example, a trust may own an LLC or can have the majority owning interest in an LLC. In that case, the trustee is a beneficial owner of the reporting company if the trustee meets one of the tests for beneficial ownership. So we'll talk about that later. We'll talk about who has to report under this law within a reporting company in the next section. But I also wanted to mention that a sole mandatory income beneficiary of a trust is also a beneficial owner under these circumstances. So again, only if a trust owns a legal entity that is a reporting company, then the trust gets pulled into having to report under this law. So final thoughts on exemptions. The Corporate Transparency Act lets FinCEN add exemptions, but FinCEN explicitly rejected a law firm exemption. So all of you lawyers out there, you have a law firm, you are still a reporting company. I apologize, unless you fit one of the exemptions. For your initial reports, there is no need to tell FinCEN that you're exempt. So if you do fall under an exemption, you don't need to tell FinCEN, hey, I fall under the exemption. You just don't report. But if a reporting company loses its exemption, then it has 30 days to register. So here's some examples of reporting companies that fall under exemption but can lose it. So one example is a nonprofit that has the tax exempt status. If it loses that tax exempt status for more than 180 days, then it is now a reporting company that has to report under this law, and you only have 30 days to do it. So make sure you keep your tax exempt status if you are a nonprofit. Also, for a for-profit, if a for-profit drops below 20 employees, then they lose the benefit of the large operating company exemption if they were to fall under it. So let's say a big company makes $6 million in a year and they have 21 employees, but 2 people quit. They now have lost that exemption and they have to now report. So just be mindful of it. Okay, so how do you report? Really quickly, on or after January 1st, 2024, you can submit an electronic form through FinCEN's secure filing system website. And here is the website that you can look up. You can also just look up Corporate Transparency Act, and it'll take you to this website. The form itself is called the BOI report, and that stands for Beneficial Ownership Information Report. There is no fee required to file this report. There is no annual reporting under this law. You only submit an updated report when there is a change to the business. And so we'll talk about those changes a little later, but just to let you know, this is not like filing taxes. You don't have to do this every year. This is not supposed to be burdensome. It's just supposed to let the government know who the owners are of the business and who, and who's controlling it, basically. So when that changes or something about the business changes, then you submit an updated report. FinCEN has not yet published the form and will not be accepting applications before January 1st of 2024. So, so we still have some time. We just have a few weeks, maybe about less than a month, but it's coming up soon, but we can't file it just yet. So what happens if you don't file? Just to get this out the way. What happens if you don't file? Penalties can occur if anyone can be shown to willfully fail to report or update a reporting company's beneficial ownership information. So if you don't report or if you don't update your report timely and it was intentional, or if they can show that you're providing false or fraudulent information in those reports, then there's penalties. If the violation is a civil violation, then it'll cost you $500 per day for the continuing violation, up to a maximum of $10,000. And if there's a criminal violation, then that goes up to 2 years in federal prison for each violation. So it can be a heavy penalty not to do it. So the best advice is to go ahead and get it done. Once the information's in there, you only have to update it when there's a change. It's not that big of a deal. It's just go ahead and report. Okay. So what needs to be reported? Short answer, there are 3 types of information that needs to be included in this report. Information on the reporting company, information on the beneficial owner, and information on the reporting company's applicants. That's a really special niche, and we'll talk about each of these 3 parts next. So reporting on the recording company's information, the actual business information. The recording company bears the burden of all reporting. So what this means is under the Corporate Transparency Act, the government is not responsible for sending you any kind of reminder or indication that you have to report. You have the burden of reporting. So if you fall under this law, go ahead and report. The company must certify that the report is true, correct, and complete. So make sure that you're giving all honest information. And again, this is secure. This is the federal government security information. Very few people have access to this information. The reporting company must report its full legal name, all the business's trade names and DBAs, the address of its principal place of business, if domestic, so your business office, or the primary U.S. location for a foreign business, for a foreign company. And also report the state in which the business was formed or registered. And the IRS taxpayer ID number, the TIN or the EIN, or foreign equivalent. Okay, so that's the easy part. That was just the company's basic information that you have to give. Now we have to give the information of the beneficial owners of the business. So who are the beneficial owners? That would be a person or an entity that directly or indirectly exerts substantial control over a reporting company, or owns or controls at least 25% of the outstanding interests of a company. So those are two different ways a person can end up being a beneficial owner. The Corporate Transparency Act requires reporting companies to report all individuals and entities who qualify under either definition. And all reporting companies will have at least one beneficial owner, but there is no maximum number of beneficial owners. It's however many people fall under either one of these definitions. Okay, so let's talk about the first. We're going to go into detail of how a person can exert substantial control or own or control at least 25% of the interests of the company. So to exert substantial control, there are 4 ways to do this. One is that you're serving as a senior officer of the company. General counsel may qualify, but we're talking about the president, vice president, but we're not talking about the treasurer or the secretary. Okay, so those are safe from being in substantial control, because the president and vice president are often the ones that are making decisions and giving directions as to what employees need to do in the company. A second way to exert substantial control is a person who has the authority to appoint or remove a majority of the board of directors or any senior officer. Okay, so that may include some shareholders of corporations that, I mean, it really can. You just have to look at who can control, who can exert substantial control, who controls a lot of the company. So another way to do it is a person who exerts substantial influence over important decisions made by the reporting company. So let's say a bigwig politician has a company that they kind of operate from behind the scenes. They may not be a senior officer or on the board or anything, but the officers somehow go to him when it's time to make important decisions. That person behind the scenes is exerting substantial control if they're a part of that discussion, if those important decisions cannot be made without discussing it with that person, even if they're not a senior officer. They are also a beneficial owner. And 4 is sort of a catch-all. This is a 4th way to exert substantial control is a person who has any other form of substantial control over the company. They pretty much want to catch anyone who has a heavy influence on what the business does. Okay. And now I want to talk about the part where it said, you know, to exert substantial control over important decisions. What kind of important decisions are we talking about with a company? First, it would be deciding whether to sell, lease, or transfer assets in the company, reorganizing, dissolving, or merging a company, making major purchases, issuing equity or stocks, incurring debt for the business, or approving the budget of a business, selecting or terminating business lines or geographic focus, determining executive compensation or incentives, and entering or terminating significant contracts, or amending formation documents, bylaws, and significant policies and procedures. So if you can really think about this in terms of who makes these really big decisions on what a company does, whether they expand to another area, whether they are going to merge with another company, all these types of decisions are important decisions. And those people that are involved in making those decisions can be considered beneficial owners. So the second big way to become a big beneficial owner is to own or control 25% of the ownership or the interests of a business. Ownership is defined broadly as stocks, equity, convertible, and profit interests. So let's say for an LLC that doesn't have stocks, you may have 3 owners, and one of those owners has 30% interest in the profits of that LLC. They are still owning 30% of that company by getting 30% of those profit interests. So they are a beneficial owner. Joint and indirect ownership count towards the total. So if, let's say, a married couple decide that they want to own a business as the couple, they can count that towards the total. Options treated as exercise. So, and here we're going to talk a little bit again about trust. So remember, the trusts that own businesses that can be reporting companies under this law. The trusts that own businesses, in regards to those, sole income beneficiaries of those trusts, or the beneficiaries with the right to withdraw substantially all trust assets, those beneficiaries would also be considered beneficial owners. And also with those same trusts, any settlor of trust with the right to revoke the trust, they can revoke it, they can end it, they are also considered beneficial. And so let's say you have a business and there's people doing different stuff and you can't quite decide who has full ownership or who hasn't for some reason, then they look at the vote or the value approach. If a person holds at least 25% of any class of interests or owns at least 25% of value of the ownership's interest, then they are also considered beneficial owners. So you see how broad this definition is. It's like a lot of people can be considered beneficial owners. So this is a lot easier for the smaller companies that have maybe 1 or 2 owners. That's pretty much it. You guys are the beneficial owners. You put your name and the other information down and you'll be okay. So but just to cover who are not beneficial owners, who are the people who would be considered beneficial owners, but there are exceptions. So there are 5 exceptions to the beneficial owner definition. Minor children. So those of you who have businesses that, that are run by your children, maybe the child is a CEO, those children cannot be listed as beneficial owners, but the parent or guardian of that minor child needs to be reported instead, and identifying that parent or guardian as in their role as the parent or guardian. So just making sure that the minor children are covered, they still want the parent reported. Right? And to determine whether a child reaches the age of majority or adulthood, you have to use the law of the state where the entity is formed, not where the child lives. So let's say you had a business where the child is a CEO and you formed it in Missouri, but let's say last year you moved to Illinois and you're questioning whether or not the age of majority when the child is considered an adult. You need to look at the Missouri law because that's where the business was. Another exception is a person acting on behalf of a beneficial owner. Maybe the beneficial owner has some health issues and has someone acting on their behalf while they're having those issues. That person acting on their behalf is not the beneficial. But also, many attorneys can fall under this this exemption because we're acting on behalf of our client. A third exemption is a non-senior officer employee that exerts substantial control over the company only because of their role as the employee. So let's say a middle manager that's not a senior officer, but exerts a lot of control in the company based on their position in the company. They are not the beneficial owners because they're not a senior officer. So this is also called employees acting as employees. They're only exerting control because of their role. Senior officers are explicitly ineligible for this exemption because you're a senior officer, you're a beneficial. Another exemption from being a beneficial owner is a person who has a future interest in the company through a right of inheritance. So let's say a CEO of a company gave future interest of his, put his company's ownership interest, giving it to his child, okay? And the child has a future interest through inheritance. That child is not a beneficial owner until they actually take on that inheritance. And the last exemption are creditors for quantified sum of money. So creditors who only have an interest in a company based on a loan or a debt that they are owed, they are not considered beneficial owners, even if they're owed a large sum of the profits, let's say. Okay, so we've gotten through the exemptions, and now we know that beneficial owners are people who exert substantial control over the company or own or control at least 25% of the interests of the company. So we know that. What exactly do we need to report on these owners? The full legal name, date of birth, personal residential street address, the unique ID number from an unexpired ID document, identification document, jurisdiction which the ID is issued, and a scan of the ID itself, which must include a photo. And this does not include social security numbers. That has been made clear. You do not have to worry about putting your social security number out there. What can be acceptable as a part of the ID requirement is a U.S. driver's license or state-issued ID. If that's unavailable, a foreign passport is okay. Documents must be current when they are submitted, and there's no duty to update these documents. If there's just a regular renewal, let's say of your driver's license, or you got a new photo, you don't have to update that. The only time there's a duty to update is when there's a change to who the beneficial owner is. Let's say there's a partnership and one partner leaves and a new partner comes on, then you need to update the report to say who the new beneficial owner is, the new partner. Also, you have to update it when there's information about the beneficial owners that have changed. Maybe they've changed their name, they've changed their address, or the jurisdiction issuing their ID. Like, if you move, if the beneficial owner moves, you need to update that information so that they can still have access to those owners. Okay. So now that we've gotten two parts out of the way, we've gotten the company information that you have to report, the beneficial owner information that you have to report, and finally, the third piece is the recording company's applicant. What does that mean? A recording company's applicant is the person who actually files the creation or registration document of the company. Or it's the person who directs or controls the decision to file the formation document with the Secretary of State. So if you're the one, let's say you created an LLC and you're the one that made the filing, you are the company applicant. But if you're the beneficial owner too, well, you're just the beneficial. But a lot of times, the company, here, let me move. I want to say this. The reporting company's applicant can be an attorney or paralegal. But you only have to add the person who directs or controls the decision if there was more than one person involved in filing the registration document or creation. FinCEN caps the number of company applicants at 2, and only individuals can be company applicants, not business. Okay, so it's very limited information, and it doesn't always apply to every business that's a reporting company. And the recording, let's just see how specific this is. So to have to report on the company's applicants, companies that are already formed before January 1st of 2024 do not have to provide the company applicants info. If you're formed on or after January 2024, you do have to provide up to 2 applicants' information. However, there's no need to keep updating that information. So let's say the attorney that filed your LLC moved their office to a different location. You don't have to update that report. This is not that serious. This is not on the same level as the beneficial. Okay, so when you do have to report the company's applicant information next year, you must report the following information: the full legal name of that person, date of birth, home or business street address, and the unique ID number from a government-issued identification document in a picture. So just like the state driver's license or state issued. Okay, so when to report. Okay, we're doing good on time. So the Corporate Transparency Act goes into effect on January 1st, 2024. FinCEN will begin accepting reports on January 1st, 2024. Now, there are also deadlines you need to be aware of, depending on when you create your business. If the business is created before January 1st, 2024, you have until January 1st, 2025 to file your initial BOI report. If your company is created between January 1st, 24 and January 1st, 25, you have 90 days after creating the business to file your BOI report. So that is a recent rule. It used to be just 30 days after January 1st, but they just changed that rule, I think, a few days ago. And changed and said, people next year, they have 90 days to get used to this new law. And then after January 1st, 2025, if you create a business, then you only have 30 days after you create the business to file your BOI report. So they're trying to give people time to know about this law and get used to filing under it. But again, it's not an annual thing. It's just report once and only update if there's a change. Okay. When are updated reports due? So when you find that there's a change in the business, like I said, a change in the beneficial owner or beneficial owner's information, all updates are due within 30 days of a change. So change to the identity of the beneficial owners, the beneficial owner dies, The clock starts when the estate is settled. Another example is a new limited partner added, a change in the share ownership. So let's say, someone added more ownership to their business and now it's over 25%, then they are a new beneficial owner. A change to the beneficial owner's information, their name, address, and ID number. If there's a gain or a loss of an exemption from the definition of a reporting company. So if you lose your exemption, like I said, the nonprofits with the tax exempt status, if you lose that status for more than 180 days, you will have to report within 30 days of that loss. And so also a loss of an exception from the definition of a beneficial owner. So let's say an employee who has substantial control over the business but is not a senior officer becomes a senior officer. They get a promotion. Now that's a change in the business. So then they have to be listed as a new beneficial owner. So be careful about those promotions. You might have to report on those. So another example would be a minor beneficial owner attaining majority under the law of the state where the company is registered. So again, if they own less than 25% and then they gain more than 25% of the ownership of the business, then they become a beneficial owner. Okay. Ooh. Wow, I made it. I guess I am done. So here's the summary is basically to let you all know this Corporate Transparency Act was created to go after the bad actors and not necessarily going after the honest people. I say not necessarily because we might get a crazy president who changes that rule, but I hope not. I hope that, but the goal of this is to go after the bad actors. The honest people just have to report and carry on as they usually do. So if you have any questions, please reach out to us. We're again the CED Microenterprise Program at Legal Services, and we're actually preparing a little checklist for everyone to have. So I'm trying to get out as much information as possible. So that's what I have for my presentation. Let me stop sharing. And do we have any questions so far? Any questions in the chat? I don't see any. I have a hand raised. Let's see. I have a hand raised. There we go. Tamika Stigers. Miss Stigers, would you like to, you have your hand raised. Do you have a question?
Yes. Can you hear me?
Yes, I can.
Good afternoon. Thank you for taking my question. I just have a question. Have you guys been following this, I guess politically, as there is a lawsuit to try and repeal this act? And where do you think it's going? Do you think it'll actually happen to where we will have to go through this process?
Even if they do repeal the law, it's going to go into effect on January 1st. So to be on the safe side, I would go ahead and report just in case, but you can wait it out, because if you created your business before January 1st, 2024, you have a full year to report. So if you wanted to wait until December to report, you can, just to see what happens with this lawsuit. I think there's more than one actual lawsuit trying to stop this law from going into effect, but I don't see that happening right away because again, this was this was a bipartisan law. This is something that the government's been trying to do. Actually, they've been trying to enforce a law like this since like 2008. So the possibility that it might be somehow infringing on maybe a privacy act or something like that, it could be, but I'm not sure. I don't really know if it's going to.
Thank you.
Yeah, do you have any other questions? No.
I don't.
Okay. All right. Thank you. Anybody else? I hope I made it. Was there any questions on anything I covered? I know I covered a lot of information.
Marlene, did you say that the form, it will be available on January 1st?
Yes. Yes.
Okay. And they're going to
Yeah.
put it on the website?
Yes. And they
Okay,
will put
awesome.
it on the website. And let's see. Yes, they will put it on the website and it should be available. Anna Carlson, you have a question?
Hi, thank you so much for that presentation. It was very thorough. I was wondering who's going to have access to all of this information that's submitted to the federal government?
Yeah, it's going to be very, very few people. I know basically, I want to say the IRS, you know, because it won't even be like state government or attorneys or anything. It will be very limited to who has access. Let me see, because enforcement, who can have access? Okay, so let's see. There are varying levels of access, but it's mainly the federal law enforcement, intelligence, and national security agencies that have direct. State, local, and tribal law enforcement, intelligence, and national security agencies may have some foreign law enforcement judges and prosecutors. There's different levels. So I don't think like at the state level or the judges and prosecutors is going to be very, very limited. I don't think they're going to have a whole lot. It's mainly the federal law enforcement and U.S. Treasury officers and employees like the IRS. So like I said, it's supposed to be just top level access. It's very hard for a lot of people to get access to this.
Yeah. Okay. Thank you.
Yeah. Yeah. Thank you. Anyone else? Wow.
Well, I'm reading in the chat, someone said that the chat is disabled, and that's why some people can't send in regular chat messages, but they're putting it in the Q&A area.
Okay, so let's go to the Q&A area. There you go.
Mhm.
Thank you so much.
No
Thanks,
problem.
Stephanie. Well done, really helpful. Thank you so much. Yes, so this information is also going to be released publicly. We're putting it on our social media as well so that other people who weren't able to register or come. So yeah, we're going to make sure this is available. So this law applies to nonprofits that do not fall under the exemption. So 501c nonprofits fall under the exemption as long as they keep their tax exempt status. And there's a political organization exemption under 527. And there's a couple of different exemptions for charitable trust. And I believe it was a different kind of split trust or something. So nonprofits may have to report if they don't fall under the 501c on tax exemption. So yeah. I am so sorry that the chat was disabled.
No problem. And one message came directly to me asking,
Mhm.
what is the name of the form?
The
That
name of the
Mhm.
form is the BOI report, and that is called, stands for beneficial ownership information. So it's the BOI report.
And
So
then
that,
one last, I'm sorry.
go ahead, go ahead.
The last question that also came directly to me is, will immigration authorities have access to this information?
Ooh, that is a very good question. Um, wow, that's scary, but yeah, that one, gosh. Well, it does say federal agencies must be engaged in national security, intelligence, or law enforcement activity. So it may be possible that they can. But again, I don't think it's meant for them. So we'll see how we're gonna have to kind of see how they're using this information. Um,
I have a question.
yes, ma'am.
What's the difference in the information that the federal government already has access to versus what they want us to report?
So, I can give you an example. So let's say you file an LLC. When you're filing the LLC articles, it just requests the organizer's information and it doesn't request the owner's information necessarily. So you can list yourself as an organizer or you can have someone else organize it for you. It doesn't directly ask for the owner's information. So shell companies can be made, for example, through an LLC because they can have an attorney create the company and never list who the owners are. And technically, LLC owners, for example, are supposed to have operating agreements that list the owners, but those operating agreements don't have to be turned into the state. So no one has that information other than the business owners themselves, if they follow the law and have an operating agreement to begin with. So it is very hard for, especially the federal government to try to figure out who owns all these companies that are hiding behind, attorneys or just a general friend who created the LLC. There's no way to figure out who all the owners are or who all the actors behind the scenes of a company are. So that's what this law is trying to figure out, who those bad actors are that are hiding. And not necessarily they're not trying to punish everybody, even though it kind of looks that way. But in a way of just trying to get some transparency. That's why they call it the Transparency Act, to see who the owners are, and they have to report it.
Are the owners still able to hide behind trust?
No, because if the trusts are related, are owning a business in any way or exerting control over a business, if a trustee is doing that, the trustee is a beneficial owner that has to be reported. So they can't hide behind the trust side.
And then when they file taxes, the owner's information doesn't have to be listed on their 1040 or their 1120s.
Tax information, I guess not. Because I'm wondering, I'm trying to see how that would work.
It just seems like this is in direct violation of the whole Paperwork Reduction Act. Why you want more paperwork when I feel like there's so many times where we're submitting things to either the state or the federal government that
Right.
has our information on it. And I just don't like redundancy and busy work.
I understand what you're saying. I understand what you're saying. And so I know that a lot of people are not happy about this law for that very reason. And just they feel it's an invasion of certain privacies, maybe too, because it's not just asking for the owner's information, it's asking for people who have substantial control over the company that are not necessarily listed as an owner.
It seems like it would be easier just to make so that if you're gonna file an LLC, just to change that to say whoever the owner is their name has to be there and not have to do a whole nother set of paperwork.
Exactly, exactly. I agree with you. I agree with you. They need to change the forms of the filings of these companies rather than creating a whole new report that everybody has to figure. I agree. But at this point, this is where we are. And so we're just trying to get the word out so people know about it and know that they need to go ahead and report unless this law gets repealed or shut down by the courts. So I understand the frustration, believe me. But, well, okay, everybody. Are there any other questions, concerns, anything? If not, then we can end this early, and everybody have a great day. And thank you so much for coming. And again, I will send out this information to everyone, and let us know if you have any questions. So thank you. Take care, everyone.